Go ahead, Alexis. Thank you.
Okay. Welcome to the workshop on legal interpretation with Duncan Kennedy. I'm Alexis Alvarez-Nakagawa, the host of the workshop today, as Evan Anopoulos, the appointed chair for today, has had some last-minute technical issues with the connection, with internet connection. So this workshop is a result of the collaboration between the Group of Critical Studies in Politics, Law and Society at the University of Buenos Aires, or PODES by its acronym in Spanish, and the Center for Law and Society in a Global Context at Queen Mary University of London. PODES seeks to problematize the legal and political phenomenon from a critical and interdisciplinary perspective, aiming to develop and promote forms of collaborative academic work and horizontal research networks with local and international projection. For its part, the Center for Law and Society in a Global Context is a home for multidisciplinary and interdisciplinary research into the global dimensions of law and society. At its core, the Center aims to work towards a better theorization of law in its changing social context, exploring the challenges posed for this endeavor by law's increasingly important global dimensions. We are glad and honored to have Professor Duncan Kennedy with us today. Our speaker does not need an introduction, but let me briefly say a few words about him. Professor Kennedy is Emeritus Carter Professor of General Jurisprudence at Harvard Law School. He was a founding member of the critical legal studies movement in the 1970s and one of its leading figures, as we know very well. His many publications have contributed to legal and social theory, the history of legal thought, legal semiotics, law and economics, contract law, and legal education. It is no exaggeration to say that he is one of the most influential legal thinkers of the last few decades. His work on legal interpretation, in particular, has shed light and changed how we understand the law and what judges do when they interpret it. In this online workshop, Professor Kennedy will present his ideas by revisiting one of his articles entitled "A Left Phenomenological Alternative to the Hard-Kelsen Theory of Legal Interpretation." Discussants will comment on this work and, I hope, also challenge some of the ideas in this paper. After that, we will open the floor to have a few rounds of questions from the audience. Let me say finally that this workshop is being recorded and will be posted online after the event. And so without further ado, dear Duncan, the floor is yours.
So let me begin by seeing, am I muted? Can you hear me? Alexis?
Yes.
So I'm really thrilled to have this event, partly because my experience in Argentina, again, which was in 2017, I think, was a very exciting one. Exposure to the Argentinian legal theory community at that point was really great. And it's amazing to see this large number of people who have signed up. It's a little intimidating. It's making me quite nervous. But it's also, thrilling in its way to actually think that so many people have done me the honor of showing interest by registering. So let me just briefly say what I'm going to do. I'm just going to present in highly schematic form my critique of the Hart-Kelsen construction of the legal interpretive activity and my proposed alternative way to conceptualize it. So the paper was designed as just about everything that I ever write is, as a contribution to critical legal studies, critical theories about law, critical sociology of law. So it's an attempt to make a contribution, but I'm not going to talk about the way it is or is not, in fact, a useful contribution to the universe of critical thought. I think the questions will insist on bringing that out altogether appropriately. So I'm going to then, in responses to questions, I'm happy to try to explain why I think, for example, it's left or why it's critical or whatever. But for the moment, I'm just going to do what I imagined myself doing when I gave the paper in Mexico City, which was to try to intervene inside, as far inside as you can get, to legal positivist analytical jurisprudence legal theory, legal philosophy, analytical jurisprudence, that specific discursive domain, and to make, in effect, a technical intervention designed to challenge the conception of Hart and Kelsen on its own terms and produce an alternative that would be intelligible and meaningfully critical within the terms of the discourse. So that's what I'm going to do. And then I'll leave it to the later part of the discussion for critiques both of that dimension of it. I want to isolate that dimension from the question of whether it's in any way a useful contribution, if it's right. First of all, is it valid in its own terms? And is it in any way a useful contribution to the larger critical discourse that it is supposed to be contributing to? So the paper starts out with a presentation of Hart and Kelsen as sharing an understanding of legal interpretation, which, as Alexis actually pointed out in his question, is spatial. So they share a spatial imagery in which, for Kelsen, there is the frame, and inside the frame, judgment is necessary in order to reach a legal determination. Outside the frame, there's no question. So the right answer is given cognitively outside the frame, but is open inside the frame. And for Hart, it's in a sense the reverse of the frame. There's the core and the periphery. The core is the domain in which he doesn't use the word cognitive that Kelsen uses, but he uses a series of words conveying that it's not a question of opinion, it's of more or less instantaneous judgment within the core as to what the rule is and how to apply it. But in the periphery, as within Kelsen's frame, in Hart's periphery, judgment is necessary, balancing is necessary, ethics are necessary, and so forth. So that's the structure. And the strategy is to challenge not the contents of the side of discretion or the side of determinacy, but the line between them. It's to argue that they produce the line unreflectively. So there's no problematization, there's no theorization of how the line comes into existence. And the argument that I make is that there is much to be said about that, and that can be said about that from, if you like, a classical phenomenological point of view. So here's the argument that I make. The argument is the line is the product of work by people over time. And here there's a direct influence for me of Marx's manuscripts of 1844 and economic and philosophical manuscripts of 1844 and 1845, Marx's theory of work as the essential activity by which the world is given its shape. So here the idea is the work of legal interpretation. And there the idea is to analogize that it's work in a medium. The medium is legal materials. And the legal materials are like canvas and paint. They're like headphones and speakers and a recording device. That is, you work in a medium. What you're working with determines what you can produce, but not in a straightforward way. It's not that there's a single necessary result of work in a medium. Quite the contrary, the basic experience of work in a medium is choice. So here the basic notion is the interpreter is in a situation of being able to work on the line between the discretionary and the determinate to move the line. And that activity is always motivated. So the work in the medium by the interpreter could be designed to make an outcome that appeared to be in the periphery reappear as in the core, with the result that the interpreter wishes to allege is simply legally required and doesn't require discretionary interpretive discourses, which of course exist. It's not that there are no legal discretionary discourses, of which the most obvious is proportionality. So A typical example of work would be, I want to show the law requires my outcome. It looks like an open, difficult case, Your Honor. It looks like there are many considerations. It's going to be hard to do, but no, it's actually an incredibly easy case. It's in the core, or it's outside the frame where interpretation is necessary. Look, listen, nothing could be simpler. But work can be aimed in the opposite direction. It can be aimed to show that what looks like a really bad result for your client or your idea of justice, so that it looks as though it's outside the frame or in the core. No, it's actually an open question. And now I'm going to address you as the audience using the open-ended interpretive techniques that will allow me to produce an interpretation still of the legal materials in which the bad case from my position becomes a difficult but intelligible case for my position. So it transforms legal determinacy on the other side into open texture and my argument for my position within the frame or in the periphery. So, and then you can also try to work addressed to the line. There are 4 possibilities. It's obviously a little box diagram. You can be moving it into the periphery for purpose and so forth. I don't think I need to repeat that. So that basic idea then is that the experience of interpretation, this is the experience of the interpreter, is to be engaged in work. It's a pretty important idea here that it's work with a purpose. So it can be for the client, but it also can be imagining the doctrinal writer or the judge. It can be with a background notion of a transcendental aim, which could be justice, equity, equality, some kind of idealized understanding, which would be the frame of the enterprise. Now, it's a basic second aspect of the experience that the choice of what work to do is, if it's not for a client, if we don't understand it as instrumental in that sense, but if it's around some universalizable or transcendental idea of the enterprise, it's an aspect of the modern experience for many people, not for all people, not necessarily, that when you set out to make arguments of that type, you experience yourself in a domain of contestation. Because you as an interpreter, if I think you're a typical sophisticated interpreter, understands the choice of how to frame your desired result, even given a universalizing project, as putting you in a domain of contestation, which could be described as political, moral, ethical, or ideological, in which transcendental ideals that you're going to apply. Remember, you can't rely on the law in the core or the law outside the frame. You're now pursuing an interpretive project, which presupposes those things are there, and that it's legitimate for you to try to move that line in accordance with your strategic goal, which is justice. It's not, but the experience is justice is ideologized or politicized in modern legal culture. And the experience of the politicization of contestation, ideological presence, is actually something described by Max Weber as the inevitable result of the derationalization and disenchantment of the world, although he basically thought you could stave it off for law by some kind of bad faith formalism. But he clearly saw the problem, which is the generalized experience of the disintegration of the coherence of large ethical understandings. So law is no different. So it's the basic experience is choosing where to push the line is a choice that comes from a project, and you would be an unself-conscious judge or doctrinal expert if you didn't understand yourself as then implicated in the contested domain of ethical political choice in our time. So then the second thing, the second aspect, and this is the last aspect that I'll mention, is that here, if you have this understanding of where the line comes from, now forget that for the moment, what does the line look like at any given moment? The answer to that is that the line between the core and penumbra, the line between the frame and outside the frame, is the product of this work by people over time. So the line is where it is, not as a result of intrinsic properties of the norm in question, but the way it is experienced as belonging on one side or the other is the product of the history of work by advocates, interested ones, disinterested ones, self-consciously political ones, self-consciously anti-political. Rule of law is all political. No. All of these people with their different points of view are all working at projects about the location of the line. And so the way to understand it is where the line is located, is the line is located as part of work, which is never fully individual. That is, the work is always in a social, political context, discursive context, which influence the way the worker works, and that means there's a circle. So the law transforms people working in the medium, constraining them, and they then work in the medium against those constraints and transform it. So there's a hermeneutic circle of a classic kind. And a very important consequence of that, now looking at the general aesthetic, the architectural aesthetic, both Kelsen and Hart, is that it makes it possible to question the top-down understanding that they both have of how law emerges and evolves. So as opposed to the notion that more abstract norms are given concrete meaning by the interpretive process, here the idea is there's pressure in the opposite direction. In other words, work on particular, the work of interpretation can react back upwards by creating conflicts and gaps at the ground level that force revision of the abstractions. So the abstract norm doesn't float freely till it's applied. It's also partly a response to, in the interpretation of the norm, to the pressure from below. So it's both an up and a down process rather than a top-down process of further and further specification, rendering the norm more and more determinate. So that's the structure. I hope you found it intelligible, and I hope it convinced you that there's something there. But as to what it means, so of course, one level of this is I went to law school. Hart, Kelsen, and Dworkin were the rulers of legal philosophy. So as a student, I experienced strong generational rage against right answerism in Dworkin. No right answers, no right answers. And then actually, Hart and Kelsen figured in our imagination. We thought they were formalists. We didn't understand that they were not formalists, but nonetheless, the element of legalism in their core and frame ideas also provoked a certain kind of 60s-ish emotional reaction, for which I claim I didn't really understand them at all as a student. I just wanted to participate in the argument in a bad boy way. So this paper is actually addressed backwards in time, truly backwards in time. The only question is, yeah, just because it's addressed backwards in time and was written, 20 years ago, that raises the interesting question of this: can it be alive in any way today in a completely different context from the one in which I was a student and then in which I wrote it as though backwards at my teachers? Thank you very much. Ooh, I think you're muted.
Oh, Yeah, sorry. Thank you, Duncan. As I was saying, for those insightful thoughts on and for revisiting, your paper and telling us a little bit more about the context of this article. I think that people will have lots of questions, but first we are going to have a round of questions by the discussants. So since I'm the chair, I'm going to invert the order of the presentations and have Illan Wald as the first discussant. So Illan is professor of law and co-director of the Center for Critical Legal Studies at Warwick University School of Law. So Illan, if you are ready, the floor is yours.
Thank you. Thanks for the invite, Alexis, and thank you for the paper, Duncan. So at the heart of it, I wanted to ask a pretty simple question. That is, if we think about texts as historically and spatially situated, then what are the stakes precisely of engaging with Hart and Kelsen in 2004 in Mexico City? So I have a couple of minutes. Let me just unpack that a little bit by talking about a series of dislocations at play in this sort of work, and I think in all of the kind of critical work that we might do. So we've been asked, as Duncan has explained, to think about this article, a left phenomenological alternative to Hart/Kelsen on legal interpretation, a text which I think many of us are already really quite familiar with and have taught for many years. But so this text is written in 2004, and the article, as Duncan has explained, revisits that critical legal studies critique of legal determinacy. The year 2004, I think, is interesting, right? Because as a starting point, it's sort of already after an end. The so-called death of critical legal studies, or at least that first wave of North American critical legal studies, is often dated, sometime in the early 90s. So 2004 is late for that. The piece is framed as a rejoinder to Brian Bix, who Duncan tells us misses the point of indeterminacy argument. And so here we have our first dislocation, a dislocation between the CLS movement of the 70s, 80s, and early 90s, and the ongoing persistence of critique of legal apparatuses. And this is a dislocation, I think, that insists on the persistence of the critical legal project, and the continuity of the question of judgment and interpretation as the core work of CLS. So Duncan revisits that core element of that first wave of CLS, the indeterminacy thesis. He does so for an event in Mexico City. And this, I think, then is dislocation number 2. That first wave of CLS was famously oriented around the politics of a number of elite law schools, the move from Yale to Harvard, the politics of the Harvard Law School, the 10-year wars, etc. So how does Duncan respond to this call from Mexico? Well, he undertakes a third dislocation. He turns to the arch positivists of the 20th century, the twin poles of Kelsen and Hart. And I think the choice of interlocutor is really interesting, right? Because they frame the stakes of the intervention and they shape the audience to some extent. Hart and Kelsen, Hart/Kelsen, H/K. Duncan tells us they need little introduction. Hart, whose positivism still held an intense grip at the time, and maybe still does, on many different Anglo-American law schools, and Kelsen, whose grip in the Anglo-American sphere, but also on the civil law system, I think was equally intense. These are arch liberal legalists, European liberal legality at a certain high point. So let me pause here and add a dislocation of my own. So I was first exposed to Duncan's work in the final year of my degree. We had a long jurisprudence module. We had a whole semester on natural law from Aquinas to Finis. We had a very dark winter month on Rawls and Nozick. And then the crits arrived. They got half of a week at the beginning of spring. And it was one lecture out of 32, but it was enough. And for me and for many others in my class, I think it genuinely felt like this moment of spring, right? The lecture opened up the law as we had been taught it. It exposed that sham, that certitude, that predictability of Ireland's liberal rule of law. And I think many of us had had that sneaking suspicion all along, but that first wave of critical legal studies seemed to pose something deep and important. It asked us whether the grounds of liberal legality were all that secure. And I think for many of us, it cracked the foundation and allowed further exploration and a variety of different careers, primarily in the UK. So I graduated with a law degree from University College Cork in 2003. And while Irish legal education was deeply oriented towards that liberal positivist tradition with a persistent but kind of waning question of religiosity, the country around us had changed and had turned increasingly to neoliberal social and economic forms. And looking back now, I see that the legal education system hadn't fully grasped the nature of this change. And thus that first wave of CLS seemed to very clearly do something radical, precisely because it was oriented around liberal legality. It seemed to perfectly challenge the forms that we had been taught, but maybe not the way the country was turning at the time. Ireland was in the grips of neoliberalism. It was in the grips of a tradition that, as Wendy Brown puts it fairly recently, hollowed out the core of liberal legality. She says neoliberalism is a termite. It doesn't directly challenge liberal norms like a lion, she says, but rather it burrows down into them. It secretes the market into the normative structures of the law. And the market does the work of consuming the norms from the inside out. Corinne Blalock has recently shown that this, I think, poses a major problem for that first wave of CLS. All the talk of disruption and thrashing and even indeterminacy is grist for the mill for some modes of contemporary neoliberalism. What was terrifying for liberal legality then maybe ends up sometimes being quite useful for neoliberal legality. So returning to Duncan's text then, I wonder about how we might look back now, today, and think about the situation of the text differently. So it engages with these arch theorists of liberal legality, but at a moment where neoliberal legality was ascendant. It targets liberal legality in Mexico, which had been subject to a decade of neoliberal adjustment at that stage, at least. It's oriented around processes of decision and rule in a time of increasing government and deregulation or regulation. So rather than seeing this as a reflection on those indeterminacy debates of the 1980s, I think today we might place the text in a much broader sweep of neoliberal history, of neoliberal legality, right? And this can be constructed from theoretical developments in the mid 20th century, institutional developments in the 70s, and then if we're thinking about ends and this question of whether or not neoliberalism is in its death throes, then the Black Swan of 2008, the popular movements of 2011 to 14, the global rise of the far right, and then COVID perhaps as maybe some sort of signal of a shift of something new and maybe something even more terrible emerging, right? So however we begin to figure the beginnings and the putative ends of neoliberalism, that date 2004 remains squarely at its apogee. And so the question becomes, why Hart and Kelsen at that moment? So let me do one more dislocation before I hand back to our chair. So I want to ask this question now, not to demand a defense from Duncan of his position then, but rather to open a discussion of the stakes of critical legal studies in the present. So in the narrowest senses, when neoliberal legality burrows like a termite into normativity, deploying the market to hollow out law, then how useful is the critique of judgment? How important is the courtroom as a site of deconstruction and thrashing? Does indeterminacy still offer a left critique? Does it still offer something to a left critique of legal relations? Or are there other modes of critical legal thought which are now maybe more important than that question of judgment? And so I come back to the starting position, right? So at the heart of it, I wanted to ask a pretty simple question about thinking about texts as historically and spatially situated. And if we do that, then what are the stakes of engaging with Hart and Kelsen in 2004 in Mexico City? And what are the stakes of engaging with that engagement today in Argentina at the maybe end of neoliberalism? Thank you.
That's wonderful, Illan. Thank you so much. Duncan, would you like to reply?
I think I would. I think I'd like to. I know that my demented brain will not, even with notes, be able to retain 3 questions. So I think I need to answer briefly to each one. So Illan Walls, that's a fascinating intervention. I'm really glad to have gotten it. And let me respond to the the dimensions one by one. So the first one would be, so it's all about the stakes of Mexico City in 2004. So what was I doing there? Well, Emer Flores, who is a Mexican legal philosopher, legal theorist, was the organizer of the International Meeting of Legal Philosophy, the IVR, which that year was in Mexico City. So I was there invited to participate in the core of the core discourse that I just referred to at the beginning. So this was an assemblage of Hart, Kelsen, Dworkin fanatics. It was in the heart of their heart. Immer invited me clearly thinking I would say something that would make it more interesting, whether it's inclusive positivism or I can't even remember what the opposite of inclusive, I guess inclusive or a non-inclusive positivism, which were the main preoccupations of the field at the time. So that's what I was doing in Mexico City. So this paper was designed to be, as I said in the beginning, an intervention for that group. But at the time, I didn't actually deliver the paper because there was this large audience of Mexican law students who'd been dragooned into coming by their professors. So I gave instead a denunciation of neoliberal law as it was evolving in Mexico on its legal fetishism. Because it was actually, although neoliberalism, your diagnosis of the seems optimistic in one way, in Mexico City at that point, the Chicago boys were discredited. History had invalidated the particular invitation of the Mexican economic, financial, cultural elites to invite Chicago to remake the social state created by the Mexican Revolution. So it was completely something that was very present to everyone's mind. Now, that leads me to my second point. There was no question in my mind, and there isn't today, that there is no neoliberal legality. And that idea, I think, is just wrong. I think it's a serious mistake, which comes from not making the transition from thinking social theory to thinking the social theory of law or critical theorizing about law. So I would say that in my speech, what I was dealing with was the experience of Mexican law students. They were being trained in something far more. In fact, your Cork would have been Paris compared to the way they were learning in their universities to understand the legal order. So they actually, their understanding was positivist. And so there's no, what is going on in the neoliberal moment was simply that the law is the law, and faced with the law, you are helpless. There is no such thing as the posture of the critical interpreter with the project of fighting back the legal forms which the neoliberal project took. Now, those legal forms, as I understood, were exactly the forms of liberal legality. I think it's simply a mistake to think that, I think Wendy Brown is pre-crit. Simply, now, Corinne Blaylock is not, but Wendy Brown, termite. So what is the law that a termite could eat it away? It's a completely formal idea. It's actually a formalist understanding of the legal order that gives it the quality of wood that can be consumed by a termite. So it's substance versus anti-substance, pure nihilistic anti-substance. This is not a good way to think about it if you're a social theorist. The law is not a piece of wood. And so also what it reflects is the liberal left longing for legal certainty to be that our politics are right, because they're not just right, they're also right in the legal sense. They somehow combine substantive correctness about the role of the government with something very different, which is the idea that the legal form is ours. We own it, our people own it. It is an expression of all that we believe in, and our ideological enemies are both want to transform society and they want to take away our precious possession, which is legal certainty. They're taking away the wood. What will we do without wood? That's a really deep reaction of modern American liberal left to what ought to be the basic experience of modernity, which is all that is solid melts into air. face it and grow up. So that's my basic reaction. Now, within the question of the neoliberal legality, the idea that critical legal studies in any way, so neoliberalism is hyper-legalist. So there are two critiques of critical legal studies, which are opposite and contradictory. One is that indeterminacy destroyed the rule of law. So on Sunday, I'm going to a conference where the theme is, how do you defend indeterminacy? It destroyed the rule of law. And that authorized neoliberalism, because neoliberalism doesn't believe in the rule of law. So this seems to me implausible. It seems to be, I mean, just it's implausible because, you know, what one says in Mexico City, I love the frame of the question is actually beautiful. So in Mexico City, how's my intervention? Well, the answer to that is the impact of the indeterminacy critique on neoliberal legalism was nil. They've never absorbed for 1 minute any aspect of the critique. In fact, the whole rights thing, so the whole rights thing is the core of neoliberalism. On one level is markets or privatization, and the other level it's private rights, property rights, expanding, not contracting. So it's not a contraction of the domain of legality, and it participates in the other side of the current liberal neoliberal thing, which is constitutional rights. So constitutionalization of everything for both the liberals and for the right, they're both into constitutionalizing everything. The CLS critique of indeterminacy has never been more appropriate than it is today, given the law fetishism that operates now, and Ireland is no exception. Everything's being constitutionalized in Ireland too, on the left and the right. So this is a global phenomenon. So my basic response to you is there's never been a better time than today to absorb as fully as possible the CLS critique of the determinacy, whether it's Hart, Kelsen, Dworkin, or Sandra, or if you like, you know, the Roberts Court in the United States, or the free copyleft movement, which is also a form of reverse commodification on the left. Just throwing in that in at the last bit.
Fantastic, thank you, Duncan. So I'm conscious of the time, so I will hand over to the next discussant to comment on Duncan's paper. So the next discussant is Mariana Prandini Fraga Assis, and she's assistant professor at the Faculty of Social Sciences at the Federal University of Goiás in Brazil. So Mariana, we hear you.
Yeah. So thank you so much. Thank you so much for having me. Thank you again, Duncan, for the opportunity to engage in the work. And apologies if I don't make much sense. So I wrote this comments on Saturday afternoon. We had the runoff of the presidential election in Brazil on Sunday. It was very emotional and big. So I don't know if it's making much sense, but to be very honest, it was so good, such a good opportunity to engage in their work, like a good diversion from all their tensions and anxiety. And I think a great reminder too that there is always a space and resources for a critical perspective on life in general, but on particularly in law, taking seriously our conscious experiences as word building and word opening. So thank you, Zach. Thank you again. So I have 2 points. They are not overarching, but rather specific to specific arguments that you make. And so as this alternative to the Hart-Kelsen theory of legal interpretation, you offer us this understanding of legal interpretation as work that consisted in the transformation of an initiation, apprehension of what legal making up the system require by an actor who is pursuing a goal or a vision of what they should require. So I find the definition of legal interpretation as work using Marx very compelling, and I think really relevant, because I think it really stresses the materiality of law and also of its consequence. I think as law students and practitioners, we need always to be reminded how law is material, because it's really easy, you know, like to get lost like in what seems like immaterial about law. And I think this is really so good. And as you go on to clarify in your piece, I think work presupposes a medium, something that the worker fashions. And in this case, this medium is the body of legal materials that are considered relevant in establishing the meaning of the norm applicable to the facts. So your acknowledgement of this materiality of the law goes further to recognize that the legal material constrains legal work, but in the way a medium constrains any worker. And so my first question is precisely directed at the work done by legal materials themselves. So up to what point do legal materials constrain legal work? And with the acknowledgement that they do, are we attributing any kind of agency to legal materials themselves? And if so, wouldn't they participate in legal interpretation in a more important role than only as a tool? So here I could not help but think of Annelise Rayos' work on the agency of technocratic legal form. And so by setting up this agenda that takes law technicalities seriously, Rayos invites us to examine technical legal knowledge itself, the theories, the models, the arguments, the techniques, the technical, not as an effect or a byproduct, but as a tool of more important agencies and forces as protagonists of their own account. So I wanted just to hear more from you about what it is about this materiality of the legal form and the legal materials, and what does this materiality does to interpretation itself if we take seriously the agency of the materials. And then the second question I have is related to the role of ideology in your theory of legal interpretation. So you claim that the activist judge who consciously or unconsciously pursues his own ideological commitments rather than claiming neutrality is the more ethically plausible position to have. As such, the work of legal interpretation is always inflected by ideology. So in your own words, and this is on page 168, the biases of judges are relevant because they orient legal work by judges or other jurists to transform initial apprehensions of what the materials require in the particular direction suggested by the jurist's material or ideal interests, loosely the ideology. So here I started thinking about a whole debate in political theory of the primacy of the political, right? My work really here concerns the ability of the legal ideas to influence ideology in the hermeneutic circle that you describe. So you had described this hermeneutic circle, and you suggest there is a balance there between legal ideas and ideology. And I think in your presentation today, it came out as really like this history that unfolds and all this historical collective making of legal interpretation, that this is not an individual producing something, but there is a baggage there, and there is like a collective word making of legal interpretation. But so my question is really, doesn't the role of ideology in legal interpretation runs the risk of taking us to the primacy of the political and not the juridical or the legal? So that's to say, what is in this hermeneutic circle ensures that the role played by ideology and legal ideas will be somewhat balanced, so that none of them completely determine the result of the work of the legal interpretation. And if ideology does trump legal ideas, ultimately, what makes law different from politics? Thanks again for the opportunity. Yeah, it's a wonderful to read you again.
Thank you, Mariana. Duncan?
Thank you, Mariana. Thank you very much. Your summary of the paper is much better than the one that I gave. Well, I should have simply recorded it and given it first. It's great. For the second question, very simple, straightforward answer. The answer is, to your question, is nothing. Absolutely nothing guarantees that politics and law in the hermeneutic circle will be in any particular balance. So in some periods, legal formalism is so deeply ingrained and believed in a given legal culture that the two spheres really do appear to be autonomous and their intersections are accidental. So the law suddenly appears through whatever institutions empower it, and bang, that's it. Sometimes in Europe, it used to seem some way that way in Europe. So an example of weirdness would be the idea that in the financial crisis, 2008, the European Court of Justice was going to decide whether it was permissible for the European Bank to buy back Greek bonds. Huh? The system is collapsing, and it's a legal question for interpretation of the treaty, whether the European, so that's the absurd primacy of the legal. But it seems obvious that law in other places is highly politicized, it's more politicized or less politicized. So the answer is nothing guarantees anything. So they go back and forth. And by the way, it's not necessarily good when law predominates at all. I'm not a legalist. So sometimes I prefer politics to dominate. So that's the first. The much more interesting for me question is the question of agency. So I have a little exposure, a little irritated exposure to Bruno Latour's thinking about things like this. And particularly, there's one of his followers who wrote a fantastic paper about the agencies of oysters off Brittany, in the English Channel, in the regulation of oysters. So basically, the article says, let's take the point of view of the oysters. They're the shellfish resource of the fishermen, and they're ecologically important. That's from the point of view of the people on the ground and the planners. But let's take it from, let's actually drop that. Let's treat the oysters as actors. So the oysters reproduce. They act by reproducing as shellfish. They proliferate, they shrink, they invade, or they recede from their invasions. They leap forward onto the page of illustrations as symbols of this or that, in which they impose their oysterness on the human imagination, looking for examples of that which contains pearls. So the oysters grow their pearls to influence the humans. So great, I love it. I think you're a little bit on that line here. So the desire that it should be the case, that the way to understand the legal materials. So, and especially when people start talking about the technological or doctrinal structure. So the idea of their agency is, I think, sort of what I'm trying to get away from. So the normal doctrinalist understanding of law is precisely that its forms and its structures are incredibly powerful actors in the world. So the CLS defetishizing agenda is precisely to deprive the materials of the astonishing fantasy fetish power. And there, the fetish idea of Marx is the idea of his understanding of the fetish. He wasn't an anthropologist, and the anthropology of fetishes didn't yet exist, but it does exist today, and it's very similar. So the idea is to explain events in the world, you appeal to the desires and influence of this object, which is endued with those powers. So I'm accusing you of longing for the fetish. So it's the idea, that would be the idea that the law was speaking, producing like a person, determining what it is in the world as legal truth. Now, against that, the whole critical move, it's the same with God in Feuerbach, so, and in Marx. So with respect to God, with respect, again, in modern feminist or LGBTQ queer theory, it's the same with identity. Judith Butler would be a perfect example of this. It's to get exactly away from that experience that gender is a truth that speaks itself through you. Now, having said all that, let me come back to the other side where I agree. So I I wrote an article which was an attempt at a critical phenomenology of judgment, which Elan would say is irrelevant, but nonetheless, it was a fun thing to do. And there I found myself, as I was trying to get into the phenomenology of legal judgment, I had to admit that I couldn't understand my own engagement in it as a doctrinal scholar when I'm being a doctrinalist without a category which I called the voice of the ancients. So there I'm sitting there trying to figure out what the legal argument I'm going to make that will work, that will be powerful in the context. I know I may fail because work is often unsuccessful, so work can collapse, and I'm thinking about what I have to deal with in the materials. And at some point, I find myself thinking about this judge who wrote this opinion. Well, what would he say about that? And that's the voice of the ancients. Now I can say, shut up. I mean, I'm free in relationship, but there's no question in my mind that the phenomenology of judgment involves an internalization of what I would call a voice. And that it is a powerful constraint, by which I don't mean it determines an outcome, but it's in the path of your journey towards the outcome that you work. And that voice can stop you in your tracks and say, no, 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 or it can encourage you and say, keep on going in this direction. So I'm willing to have this fantastic fantasy-based idea, but I really am not in favor. So the oysters, it's fun, it's a brilliant article. I wish I could remember the guy's name. So it's better than anything Latour, I thought. I love it, but I'm not going there myself. I'm just going to eat the oyster.
Okay, thank you, Duncan, for your answer. So I think it's my turn now, but I'm also conscious of the time, so I'm try to go very, very fast. And maybe I have 3 questions, so maybe I will keep one for myself. Let's see. So, well, as I said before, I'm Alexis Alvarez-Nakagawa. I'm a lecturer and fellow of the Institute of Humanities and Social Sciences at Queen Mary, University of London. My first question, Duncan, is the following. And you anticipated a little bit this question in your presentation. So in your article, you briefly point out to the spatial vocabulary and imaginary deployed both in Kelsen and Hart, right? Especially when they talk about indeterminacy using terms like core of certainty, area of open texture, frame, and so on. And this is fascinating for me. It's a very, very interesting point. But as soon as you notice this spatial imaginary in positivism, you set aside the issue by saying that it is not relevant to the discussion that follows in your article. However, I was wondering why you do that, because your phenomenological approach seems to me to borrow from a temporal imaginary in contrast to the spatial imaginary of positivism. For example, you temporalize the problem of indeterminacy by setting it in the frame of practices of interpretation over time, or of in other words, of determinacy and indeterminacy. Indeterminacy would be, as you say, the result of strategic interpretative practices. So my question is, why is it that you don't delve into this contrast between your phenomenological temporal approach and positivism spatial imaginary? This issue seems to be relevant to the discussion, particularly because if we consider that this spatial way of looking at things that positivism has, in a way, it might blind positivism to the dynamism in a way of interpretation and how cores and frames might move over time, right? So, and also highlighting this temporal aspect of the, I would say, existential being of interpretation seems pertinent for a phenomenological approach, at least since Heidegger, right? So that's the first question. My second question is, as I see it, and this is a bit like a provocation to you, Duncan, as I see it, there is a tension between your phenomenological approach and your more general leftist understanding of the law. Because by putting in epoche, but that is by suspending the question of the ontology of the norm, that is whether the resistance that the norm presents to the interpreter it's part of its essence or just an effect of interpretation or of interpretation over time. That is, by bracketing the judgment on this question, I have the impression that in concrete, you put out of the picture part of the lawmaking process, in particular, the legislative process and the fact that the laws produced in that context are already loaded with meaning. So while in other writings, for example, in your book, Critique of Adjudication, you are very clear about the bias of the liberal law in favor of maintaining the status quo, your phenomenological theory of interpretation in this article seems to leave norms' ideological bias out of sight, concentrating on judges' experiences. So why bracketing what helps to explain why and how the legal work of interpreter starts? Do you agree there is a methodological tension between your phenomenological perspective and your leftist examination of liberal law? Would you explain why the phenomenological reduction would be helpful here and not counterproductive to understand the whole process of lawmaking? Yes, I have time for one last question. I will be very brief, I promise. I find that in your paper, you discuss your phenomenological approach, but at the same time, you do not say much, or you do not explain why this will be a leftist take on legal interpretation. And this seems to be important because it's part of the title, right? It's a left phenomenological alternative to Hart and Kelsen. In other articles, you have described why your project is leftist and have related this term to oppositionism, among other things. But I wonder if you can say why it is important for the left and for critique to engage in this discussion about legal interpretation. And in this, my question is in a way close to Illan's questions, but in a different kind of way. So don't you feel that by intervening in this kind of discussion, one contributes to canonizing a field whose boundaries, parameters, and contours were set somewhere else, for example, by legal positivism? Does this strategy not risk limiting the scope of critique by keeping it confined within the given discussions? Why not pushing leftist critique beyond the established frame to sing the law of the given, beyond the debates already set by liberals and positivists? I'm wondering why for you, and also, to be honest, for CLS more generally, if you can say, it was important to oppose the tradition within the tradition, that is, not breaking entirely with it. So that's my last question, Duncan. Thank you so much for listening, and I'm looking forward to your answers.
So this is very. I'm unmuted. Yes, I am. So this is a lot, and I'm sure that I won't have gotten the subtlety of each aspect of the questions, and maybe I'll have forgotten them and have to ask you to remind. I probably will have to ask you in a minute to remind me of the last question. So for the spatial temporal, in fact, I guess I really don't understand how, so to me, it would seem that the particular phenomenological mode that I practice in the paper, while it's not Heideggerian exactly, totally totalizes the spatial and the temporal, because in fact it's exactly an example of not expecting of treating the spatial, relativizing the spatial in time and making time a function of the spatial or material. So it's actually an attempt to write without falling either into a revision of a spatial map or reducing the law to a narrative in which anything can happen in the novel according to who the narrator might be. So I guess all I can say, maybe I just don't get your question, but that would be my brief response to it. So if I get the second question, again, I'm not sure that I do. So what about so if the core of the second question is what about legislation? So in your picture, in my picture of the judge, legislation, and this would be a tricky question, which I'd like to have a good answer to. I'm not sure whether I do, but might not be what you're talking about. Given that the legislative process is overtly ideological, and statutes emerge out of a debate in which, rather than being excluded as they are in legal discourse, as inappropriate for legal discourse, the ideological discourse is front and center, and you might say, in Mariana's terms, the ideological discourse underestimates the extent to which it's already determined by prior legal discussion. So as opposed to completely obscuring the existence of the ideological debate, it's the opposite. It obscures the extent to which prior legal background rules sedimented and structuring the legislative discussion have largely limited the possibilities of ideological debate. So, but I don't know if that has anything to do with your question, but at least from my point of view, when the judge, but not the doctrinal scholar, the most basic audiences here are people who engaged, as Illan said, in legal judgment interpretation, but that actually includes legislators. So legislators constantly debate the legality and illegality of what is proposed, not just in constitutional terms, and they constantly evoke legal argument in the legislative debates. So it's true that ideological arguments are foregrounded, but the whole legislative process is deeply, deeply conditioned and operates in a legalist sphere. So from my point of view, when the guy makes his speech on the floor, or the woman president of the assembly rules a particular intervention out of order, or protests that whatever, then the critique of liberal legality, so to speak, which is also neoliberal legality, completely neoliberal legality, is completely pertinent in that sphere as well. But maybe I didn't get it. So I'll let you follow up in a sec, but then, so can you quickly say again the third? So as I said, my memory is a problem. So tell me the third question quickly, because I'll remember.
Yeah, well, very, very quickly. The question is, in your paper, you focus mainly on your phenomenological approach, but do not explain why this would be a leftist take on your interpretation. The question is, why not going beyond the established discussions? Are we not canonizing this discussion on legal interpretation that was actually established by positivism or liberalism and so on? Why not going, why not breaking with the tradition? That is
okay, so good. So now we remember, so the two dimensions of it. So the first is, so I get, let me, for the question of, I think I really have given my basic answer to your question is that, first, for the first part of the question, well, no, let me start with the part where it's true that I give very little elaboration to what is leftist about the critique. And that's something I'd like to use a bit of my time, not very much, to talk about, because it's not elaborated in the paper. So a very typical reaction is, isn't your insight equally valid and useful to the right as to the left? So from an instrumental point of view, indeterminacy can be used by anybody. Now, on one level, that's a so it's obviously true. And it's obviously true of any interesting innovation in a discourse that affects the discourse, that it will then be appropriated and used by whoever. There's no political intellectual property in the uses of a contribution to a discourse of this type. Now, I think that the idea that the right has found in indeterminacy a vehicle to destroy the rule of law in the honor of its projects that are essentially counter-legal, as I just said, I don't think that's an opinion. I don't think that's a very intelligent position. I've already explained, maybe at too much length, why I think that's the Wendy Brown idea, is a fantasy about the woodenness of law that is better abandoned. And nothing Corinne says about, Blaylock says about this, modifies my view about that. She doesn't effectively critique the ideas that I just expressed in response. So let's leave that the useful for all purposes, but why is it leftist? Why would a leftist self-described person who claims to be a big radical, I claim to be a big radical, blah, 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 blah. I was probably wearing some very colorful costume in Mexico City as I tried to wind up the Mexican undergraduates about neoliberalism. I can't remember what it was, but I'm sure it was interesting and hippie-ish. So why be engaged with this? So there are two questions. One, the bad effect might be canonizing it, but first, why do it? The reason to do it is that I'm myself a part of a particular left tradition. And the particular left tradition that I'm part of is leftism is married to critique. The two are inseparable, connected. So the ambition of this leftism now to explain what that could mean is that human liberation is connected to de-reification. So anti-fetishism is a core of the left humanist project. What it is for the project of liberation to advance is to get rid of the shackles of false argument. So the basic idea is we are constricted in ourselves by Unger has the great phrase, false necessity. So a basic aspect of the left project is the battle against false necessity. Now, false necessity sometimes seems an important protection. So a little false necessity can come in handy in certain circumstances where you're endangered by a brutal authority who might respond as a fetishist and saying, gee, the rule of law, I guess I can't kill you, or something like that. But this form of leftism says you can't just say, let's go with fetishism and hope that over time, fetishism will work out better than pursuing the project of undoing it. So it's a key element of left project to defetishize, even with the risks that at a particular moment. So now then let me add, I, in my life as an activist, constantly use a fetishized discourse of advocacy. So, in the last week, I participated in a study group on tenants' anti-eviction rights in the eviction waves that are going all over the country, arguing for tenants' rights. How should we frame the argument for tenants' rights? Or then last week, I also ended up in a discussion about how to apply international human rights law to discrimination against women in the construction of urban transport networks. So that's all about how the worker, the domestic worker in a Latin American city has to go far more miles to work on public transport than the guy for whom the bus routes were designed. Okay, rights, equal protection, absolutely. But there the experience is got to be doubled. It's like religion. When you're dealing with people who are totally believers in God, a good liberation theology argument for your position is perfectly acceptable. It's morally not bad to do it, even though you're an atheist. So that's, no, fetishizing Hart Kelsen. But in the United States, Hart Kelsen, by the way, for Hart Kelsen, the audience on this Zoom call is 5 Americans. Someone asked, are there any Americans, United Statesians in the audience in the chat? I don't know what the response was in the chat, but my guess is that Hart Kelsen in my universe don't exist. So that is, so when I write something about Kelsen, I assume that the only people who will read it are Europeans and Latin Americans. That's it. So I deny completely the fetishization is already there. It gives me, because it's fetishized, my own interest in the deep truth of the critique, I hope has an audience that it doesn't have in the United States. So fetishize away as long as I can be there to throw stones at the fetish.
Thank you so much, Duncan, for your answers to my tricky questions, I would say. So I'm very conscious of the time. We are running out of time. So I would like to open the floor to questions from the audience. So is there any question? Please, you can raise your hand, your real hand or your virtual one, or you can write your question in the chat. Anna, yes, go ahead.
Thanks so much. Thanks for the great paper and comments. I had a question about the centrality of property to the CLS project as it's described in this paper and more generally, and the relationship of thinking about property specifically to the choice that is made in this paper to focus on the moment of adjudication or interpretation, or the moment where you're already in the forum, you have the facts, you have the cause of action, you have the norms, and then it's a question of what do you do with all of that. I suppose because one thing that I think very much impacts on the way that practitioners experience the politics of that interpretation is the way that the forum is already structured by the process of claim making. So you might be, for example, deciding a case about economic torts and how that is going to massively expand the implications of property rights and how the economy is structured, but you might be doing it by reference to, you know, two companies that make tissue boxes or something. So you're already in a place where you haven't got the information to be able to shape the kind of interpretive choices that CLS is urging lawyers to have a sense of. I think is one kind of question for focusing on that moment. And then I think the other problem, as it appears to me specifically with respect to property, and I've been thinking about this because of teaching property and really the triad between legal interpretation, but also the work of the legislature and very significantly the work of scholars and legal historians, that judges and advocates in that field more than other fields feel themselves to have a lack of time to grapple with the weight of, you know, the history of equity or the international relations in respect of patent law. And so more than in other fields, there's a sense of, oh, we can just handball that to one particular scholar or another. And so the scholar in your account is kind of not central to the hermeneutic circle that you're describing. And I wonder how you see that going forward for the critical project.
That's a good question.
Yeah,
I think
Duncan,
this time, let's have more. Let's have more.
Okay.
Thank you very much.
Let's Emer. Yes, go ahead, Emer.
Hi, Duncan. Thank
Hi,
you for.
Ina. You realize that everything was put in question. My very presence in Mexico City was thrown in question by Illan.
Yeah, that's why I want to raise my hand and also try to explain a little bit of your Mexican intervention. Actually, one little clarification: it was not an IBR conference or congress, but it was an international conference, and there were a lot of people very important: Scott Hershowitz, Mark Greenberg, Duncan Kennedy, Brian Biggs, and from the other Latins, Cristina Redondo, Pablo. Several ones, so it was a big one, and of course Duncan, being Duncan, came with his persona, with jeans and not tennis shoes, but like just regular shoes, boots probably, and I'm not sure if a t-shirt but it was Duncan being Duncan, and. Regarding the Mexican intervention, I want to ask something else, but just to push a little bit on your Mexican intervention. I will say I studied with you and with Roberto, and I will say that you have an indirect intervention through me, even though I think I was pushed by both of you towards more a Durkheimian point of discussion. And here I like Mariana's comment on the legal materials. If we have a set of legal materials, this set of legal materials can help bring some sort of determinacy at some point. I know you are more open to work with these legal materials and make the space to work with them in either direction. So that's where your indeterminacy will kick in, and as you can go into more, you have explained the sentence that you want to go and how you can go either way. So, but I still have the feeling that the legal materials can help determine the outcome, the result. And that's why I keep being a Durkheimian, even though I was formed with both you and Roberto. But still, that's a kind of indirect intervention, pushing someone to be more Durkheimian. But I think you're right that the left has this critique, and I think the critique has kicked in Mexico in the rights discourse. I know the rights discourse is not necessarily the best example, but I think that's one of the points in which there has been some improvements, and I think that's also some kind of indirect influence from you guys. But let me ask you a question on we have discussed a lot the paper. I even did a translation into Spanish of it. It's in Problema, in the journal we have at UNAM, and trying to push you. Why were you interested in moving to a moderate indeterminacy, hard Kelsen? As you already mentioned, Kelsen was not very influential. It's not very influential. Only Stanley Paulson is a very good Kelsenian in the US. But and getting away from a more radical indeterminacy. Why making that move? It was a move to talk with them. It was a move to engage with them, or because at the end you are always pointing that law is politics, law is ideology. In that sense, you will always be more into a radical phase rather than them. But why the move? Why was the move important for you at that point?
Thank you, Imer. Juan, please go ahead, but could you be very, very brief in your question?
Yeah, thank you very much. No, as you were saying, the chair was saying, Duncan is very important for the legal education in the last few decades, and I wonder. I come from studying at Columbia, where in my university Duncan was very important. And I'm wondering, what do you think of students of law that are related to your writings and of the article you were exposing today, and that are now probably working at a national court or a regional court? What do you think of the implications of your thoughts in other countries, and especially in third world countries? Thank you.
So I'll try to answer. I'm not muted, right? So I'll try to answer quickly. So each of these questions is long enough to merit a very long answer. Let me begin. So for Anna, I guess if I could give a global answer, it would be yes, that this piece, and also my much more elaborate freedom and constraint adjudication, are focused on the adjudicator. And in critical legal studies, that focus was often criticized. And there are many reasons why one can see it as limiting, and it is limiting, but I've always somewhat resisted the argument that there's something about the adjudicative framework that is important for the discussion, although that's a strong intuition. It's like the idea of the technology speaking, like Mariana's idea. So, and the reason for that is, I think that what happens in the courtroom is the things that are excluded by the courtroom frame are many things, including history, including if it's all about the 2 boxes of tissues and the future of intellectual property is at stake, there is an absurdity about the grandiosity of the stakes that are imagined and the triviality or extremely limited context of the discussion. But the most basic but here is, so I have to say this with a certain amount of irony, the answer is actually in Juan's question. So the answer is legal education, just because it's so limited and because it's not about practice and because it's divorced from life in law, is incredibly important in structuring what practicing lawyers who practice every day think about all law except what they practice. And that, in other words, that experience of law, lawyers think they know all about law, but we professors don't think that's true. We think they tend to know about the law they practice, and that we're the ones who know about and convey the system in a very limited way. It's very limited because the class is short and the other professor is saying the opposite and the students are falling asleep and their case notes are actually the opposite of the real holding of the case and blah, 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 blah. But here there's an assertion that professors are actually incredibly influential on what happens in the courtroom in this very indirect way, because consciousness, here's where legal consciousness comes into play. Legal consciousness is not knowing about the law of landlord-tenant. Your legal consciousness is there before you learn it, and your legal consciousness affects that. So that is a model in which we professors, for all of the objection and triviality and marginality of our status in the system, can nonetheless think that we're part of a process which makes adjudication exist always in an interesting tension with what the lawyers already know and think they know about everything. So I don't think that's really so bad. And I love doing it in that context for its precision. On the other hand, okay, that's enough answer for that one, I hope. For Immer, first of all, Immer, it's so glad to see you. You look great. In fact, you look just the way you did before, which is amazing. And thank you for the invitation. I'm sorry I had no idea who was the invitation. It was your own construction, not an IVR thing. When you say they're like Brian Biggs, so why the move to soften? I was always an opponent of what I called global indeterminacy theories. So in a critique of adjudication, there's a whole chapter framing the question, are we propounding a global indeterminacy theories or a totally contextual one, where the indeterminacy is never a heart, it's never a stab in the heart of the idea of legal determinacy. So my argument is sometimes the law is experienced as radically determinate, and sometimes it's experienced as radically indeterminate. And of course, the materials are part of the story, as our discussion has been saying. So let's see, one more minute. So, I think that people who've been indoctrinated with this kind of CLS position, I think are in a better position to self-consciously, but within the limits of good faith, interpretive work and effort, be progressives in their judging. That's my hope. Now, the person who's been most interested in that is Diego Lopez Medina, and I'm not sure he wouldn't express a complicated series of ambivalences about how it plays out in practice for Los Andes students, but not just Los Andes, because the other law faculties. But my hope would be that this work would be experienced as a preview, alerting you to the policy, but not the politics, the possibilities, the dangers of, and the glory of legal interpretive work. The glory of legal interpretive work.
Thank you, Duncan. I don't see any other question, and since we are on time, I think that we are going to close the workshop here today. Thank you so much, Duncan, for being here. It was great to have this discussion about legal interpretation with you. Thank you also to the discussants, to Illan, to Mariana, to Eva as well for being here today. Thank you to Polis as well, and to the Center for One Society for being the host of this event. And yes, thank you all for being here listening as well. I would like to have more rounds of questions, but the time was limited, so I'm sorry about that. So thank you very much.
Thank you.